Good morning. Thank you for joining Mayor Brown's Global Financial Markets Teleconference Series. Today's call is entitled Madden and True Lender, Potential Impact of Recent Developments. My name is Jeff Taft, and I'm a partner in Mayor Brown's Washington, D.C. office and a member of our Financial Services Regulatory and Enforcement Group. My practice focuses primarily on banking regulation and consumer financial services. First, a couple of housekeeping items. As regular listeners will know, this call is being recorded. We will be emailing an audio link to all participants should you wish to listen to the teleconference again or forward it to your colleagues. In addition, the recording will also be available as a podcast on your preferred podcast platform. Since we will not have a Q&A session, please feel free to send your questions regarding today's topic by email to gfm@mayorbrown.com and we'll respond promptly. This is the same email address on your invitation email. Joining me today on the program are my colleagues Steve Kaplan and Eric Mitzenmacher. Steve is a partner in our Washington, D.C. office and the leader of our Financial Services Regulatory and Enforcement Group. He concentrates his practice on matters related to consumer financial services and represents clients in federal and state supervisory matters, investigations, and enforcement proceedings. Eric is also a partner in our Washington, D.C. office and a member of the firm's Financial Services Regulatory and Enforcement Group. His practice involves providing regulatory compliance advice to companies that offer various consumer and small business financial products and services, as well as conducting regulatory due diligences reviews on behalf of investors and financing sources for such companies. With those brief introductions, we will now begin today's discussion. At the risk of stating the obvious or spoiling the surprise, there have been a number of key Madden and True Lender developments this year, and we expect that there will be more before the end of 2020. Our goal today is to highlight some of the key developments, including the settlement of the Colorado litigation, the valid when made rules issued by the FDIC and the OCC, and the state AG's lawsuits challenging those rules, and the OCC's proposed True Lender rule. In the course of discussing these developments, we will provide some thoughts on their potential impact on bank partner programs, lending programs, investors, and secondary market participants. We will expect to drill down further on some of these developments in subsequent programs this fall. With that introduction, I'll turn the program over to Eric, who will provide some background on True Lender and Madden before discussing the recently settled Colorado litigation. Eric?
Thank you, Jeff. True Lender and Madden risk are two separate issues, but they both relate to lending programs or transactions that involve some sort of relationship between a bank at least nominally originating or making a loan on the one hand, and a non-bank entity providing origination-related services to the bank and or purchasing a loan or an interest therein on the back end. The two issues can arise simultaneously, such as in a typical marketplace lending program, but it is also possible for one to exist without the other, such as when a bank solicits and originates a loan by itself, but later seeks to sell that loan to an investor. As I continue with an introduction to each individual issue, I'll lay out some fact patterns that would raise either the True Lender issue or the Madden issue, respectively. First, the True Lender issue, as the name suggests, relates to questions about or challenges over which party, as between the bank and the non-bank, is the actual lender for various legal and regulatory purposes. Key issues tend to include usury limits and licensing requirements, because both of these are areas in which the bank tends to have substantially more authority to lend than does the non-bank entity. For usury, the bank's broader authority arises as a result of preemption standards under federal banking laws. Now, there are nuances and caveats as to how a bank's interest authority works. For example, what fees constitute interest, or what particular requirements other than top-level numeric caps are preempted. But in general, a bank can, quote-unquote, export the interest-related requirements of one state in order to support a national lending program. For licensing, arguments vary a bit more based on whether the bank at issue is a national bank or a state bank. But the net result is that as long as the bank is the true lender, licensing obligations for actually making the loan tend not to apply. The non-bank partner may still have licensing obligations for engaging in other services, such as loan solicitation, arrangement, purchasing, or servicing, but the true lender issue drives whether the licensing requirements apply for the lender itself, and as a result may have a substantial effect on the overall viability of a national program. The true lender issue is not entirely new. Early cases involving certain credit card and payday lending programs date to the late 80s or early 90s. They've taken on a new life more recently as a wider range of credit programs, from unsecured consumer and all asset secured small business marketplace lending to retail financing to private student lending, have chosen bank partnership business models. At the same time, courts and regulators have not evaluated a sufficient number of true lender cases to coalesce around a single standard. True lender analysis runs from a version of the world where the only thing that matters is the lender named in the loan agreement through a series of progressively more fact-intensive standards, ultimately asking questions about the totality of the circumstances, as in which party looks more like the lender, or the allocation of the predominant economic interest in the program, as in which party gains and at least risks loss like a lender would. Regardless of the standard applied, courts and regulators addressing true lender challenges are attempting to determine whether the loan was originated properly, whether it is valid, enforceable, and compliant with law at origination. The Madden issue, on the other hand, addresses a separate phase of the relationship between a bank lender and a non-bank entity. As previously noted, as a general matter, banks may rely on their interest exploitation authority to lend nationally without regard to state usury requirements other than those of the state from which they export. When they sell loans or interest therein to a non-bank investor, the question arises as to whether the non-bank may continue to charge interest at rates that were lawful at origination solely due to the bank's interest exploitation authority. Until the Second Circuit's 2014 decision in Madden versus Midland Funding, the answer to this question was not in significant doubt. Longstanding federal usury principles, the so-called valid when made doctrine, provided that whether a loan was usurious was determined at origination and was not affected by a subsequent sale or transfer of the loan. In Madden, the Second Circuit addressed a situation in which a non-bank entity acquired defaulted credit card debt from a national bank. It ultimately held that the National Bank Act does not preempt application of state usury limits to non-bank purchasers, but it did not expressly address the valid when made doctrine. Midland Funding sought review by the Supreme Court, but certiorari was denied. During the petition process, the Solicitor General filed an amicus brief indicating disagreement with the Second Circuit's conclusions, but suggesting that the case should not be taken up by the Supreme Court because it was a poor vehicle for considering the issues. Among other reasons for this stance was that there was a possibility that Midland Funding had waived the valid when made issue earlier in litigation. As a result, Madden remains binding law in the Second Circuit, which is New York, Connecticut, and Vermont. It has also been assessed by, and in some cases considered persuasive by other courts as well as by certain regulators. Having set the stage, we now move on to recent developments, starting with recently resolved litigation in Colorado. This is perhaps the key litigation-related news item in this space over the past several months and frankly, the past couple of years. The Colorado litigation involved allegations by the administrator of the Colorado Consumer Credit Code against two marketplace lending platforms, Avant and Marlette, which does business as Best Egg. In both cases, the Colorado administrator alleged that the interest rates and certain fees charged under the two programs exceeded the amount that Avant and Marlette were permitted to charge at state-licensed supervised lenders. With respect to interest rates, for example, the programs provided for annual percentage rates up to 36% or 30% respectively, depending on the program, whereas Colorado law permitted supervised lenders to charge either 21% APR as a blended rate or a rate resulting from a tiered rate structure based on loan balance, which in nearly all cases did not allow the rates that were being charged under the programs. Now, there are unique aspects to any bank partnership program, but the Avant and Marlette bank partnerships involved the same basic superstructure. Both lending platforms provided solicitation and various origination-related services to a state-chartered bank that then made the credit decision and extended credit to consumer borrowers. In Avant's case, the bank was a Utah-chartered bank, Web Bank. In Marlette's case, the bank was a New Jersey-chartered bank, Cross River Bank. After origination, and after a seasoning or holding period during which the bank retained the loans that were originated into the program, the loans would then be sold onward to the lending platform, and from there to various financing or securitization trusts. Throughout the life cycle of the loan, the state licensed entities provided servicing for the loans, whether the loan was held by the bank, by the platform itself, or by a subsequent trust. This gave the Colorado administrator a hook to apply Colorado state-specific requirements to the programs. They did so through allegations as to the interest rates and certain fees. There were also allegations as to the legality of a choice of law provision that selected a state other than Colorado, though the focus was on rates and fees. The Colorado administrator's claims were grounded in two theories. First, a true lender theory, that Web Bank and Cross River Bank were in fact not the true lenders, but that rather Avant and Marlette were. And as a result, at origination, the loans should not have been permitted to bear interest or fees in excess of those permitted under Colorado law. As a backup to that theory, the Colorado administrator also asserted Madden-based claims. Specifically, once the loans were sold from the originating banks, the loans could not continue to bear interest or fees in excess of those permitted by Colorado law. The path of this litigation is quite twisting and involves a number of terms that are relevant to understanding how courts and regulators might address these issues going forward. I'll walk through some of that, ultimately getting to the assurance of discontinuance or settlement and what that means for true lender and Madden issues going forward. But these were cases that were filed in January of 2017. Immediately after they were filed, the non-bank lending platforms sought to have the cases removed from state court to federal court. The basis for petition for removal was the concept of complete preemption, which is the idea that there is no such thing as a state-based usury claim against a bank, and the idea that all usury claims must be reviewed by and proceed in federal courts. From March 2017 until that petition for removal was ultimately resolved against the platforms in March 2018, the case proceeded in federal court. The federal court in the District of Colorado determined that there was a properly raised claim against the non-bank lending platforms themselves that was neither a disguised usury claim against the banks, nor a claim that made the banks the real party in interest to the claims that were being raised against the platforms. As a result, the cases were then remanded back to state court for further consistent proceedings. After being remanded, the state court assessed a motion to dismiss, which was rejected on the grounds that there were issues of fact that had to be resolved later in the proceedings as to the true lender claim. Following the denial of dismissal in the case, the Colorado administrator raised a motion for determination of law, asking the court to resolve whether Section 27 of the Federal Deposit Insurance Act, which is the provision of the act that establishes a state-chartered bank's interest exploitation authority, preempted the relevant Colorado interest and fee restrictions. On June 9th of this year, the state court resolved that issue, issuing an opinion that Section 27 did not preempt the Colorado provisions. Shortly following that denial of preemption, the parties engaged in settlement negotiations that ultimately resulted in the execution of assurance of discontinuance on October 18th of this year. Now, that assurance of discontinuance effectively ends not only the immediate action against these two lenders, but provides a roadmap for future action by the Colorado administrator itself with respect to other lending programs in the state, and at least potentially gives some sense of how regulators in other states might go about regulating marketplace lending programs and other programs that raise true lender or Madden issues going forward. The elements of that assurance of discontinuance include an element of monetary relief, which is by itself not extraordinary, as well as a series of injunctive provisions that relate to the structure of the program on an ongoing basis. There are 5 separate categories of requirements that the marketplace lending programs are subject to going forward. There are, quote unquote, oversight criteria, which relate to the oversight by each respective bank as to the manner in which loans are solicited, underwritten, originated, and then sold, as well as the terms under which the loans are made. There are consumer term requirements that, in their most important aspect, prohibit the origination of loans under either program at an APR in excess of 36%. That provision is limiting as to the general concept of the marketplace lending program, but actually quite informative by itself, because it is in excess of the rate in which a state licensed lender would have been able to originate these loans in the first place. In that sense, the assurance of discontinuance essentially sets aside the Madden issue, permitting a bank partnership-driven structure to charge rates in excess of the state-permitted rate, provided that it meets this 36% criteria as well as other structural criteria. Given that neither program involved the origination of loans in excess of 36% APR to begin with, that does seem like a fair victory, even though there are other requirements under the settlement. The settlement also includes licensing-related criteria that require the platforms to remain licensed and to submit certain extraordinary reports to the state in order to use the 36% rate authority. And they involve, and the assurance of discontinuance also involves a set of quote-unquote structural criteria, which are perhaps the most burdensome and also the most interesting set of criteria from an ongoing structural perspective for bank partnerships in and potentially outside of Colorado. The structural criteria present a set of ways in which a bank partnership may be structured as to the origination and sale of loans and retention of credit and other risks related to loans in order to satisfy the Colorado regulators' essentially true lender standards. They're somewhat prescriptive, varying the amount of economic risk that must be maintained by the bank in order to make use of this permissive ability to charge 36%, based on factors such as the nature of the interest that's retained by the bank, the manner in which the interest is sold, and in particular, whether a loan or interest therein is sold on a committed basis, such that the bank has assurance that it will be able to sell that loan, or if it's sold on essentially a voluntary basis to the platform or to an unrelated third party outside of the contractual obligations of the bank partnership itself. Overall, the Colorado assurance of discontinuance, again, largely reads as a true lender settlement that caps interest rates in a way that would not necessarily need to be capped if a bank partnership program were to completely prevail on Madden grounds, but at a level that, at least for these programs, seemed acceptable given the terms under which they historically originated loans, but then constraining the manner in which the bank partnership is arranged and structured for true lender purposes to ensure that the bank itself has sufficient control over the program and sufficient exposure to credit and other risks to be considered the lender and to gain the benefits of that with respect to things like usury and licensing requirements. Now, the Colorado regulator itself has not yet brought any public litigation or enforcement action that mimics the actions that it had taken against Avant and Marlette. But there's some reason to believe that these terms were not created specifically around the Avant and Marlette program, and they may be quite reflective of the Colorado regulators' thinking about both the TrueLender and Madden issues. The other aspect that will be interesting to track going forward, but that the settlement itself does not resolve, is the extent to which other regulators, potentially regulators in states that are known for being relatively aggressive with respect to enforcement, be that Massachusetts, New York, California, potentially Illinois, and so forth, the extent to which those regulators may take up the same standards, and whether they believe that what makes a bank a true lender looks like what the Colorado regulator has set out in the assurance of discontinuance. For now, we have resolution of what has been a major news story in the marketplace lending and general bank partnership space for quite some time. But over the next year or two, it would not surprise, I think, any of us at all if there were contagion outward of at least challenges that raised pieces of what the Colorado regulator put down in its settlement, and would be the item to watch going forward as additional state regulators start to step into the TrueLender and Madden spaces. And with that, I will pass the discussion off to Steve to discuss certain federal regulatory developments and challenges there too.
Thank you very much, Eric. I'm going to discuss recent actions by the OCC and the FDIC related to Valid When Made and Madden. Both the OCC and the FDIC have recently promulgated so-called Madden Fix rules in order to clarify the treatment of loans originated and subsequently assigned by their respective regulated banking institutions. Jeff, Eric, and I, along with some of our colleagues, including Barbara Goodstein, were intimately involved in the rulemaking process on behalf of SFA and various clients. So this is something that is near and dear to our heart. I will begin with a just brief background on the OCC rule. Then I'll follow with a brief background on the FDIC rule. And then I'm going to discuss challenges that have already been made related to those rules, and talk a little bit about what we should expect in the future. So first, let me begin with the OCC. On June 2nd of 2020, earlier this summer, the OCC finalized a rule that it initially proposed in November of 2019, entitled Permissible Interest on Loans that are Sold, Assigned, or Otherwise Transferred, clarifying that interest permissible at the origination of a loan by a national bank or federal savings association remains permissible after any sale, assignment, or transfer of the loan. The rule was effective on August 3rd of this summer. The OCC rule is an effort to address the legal confusion, as the OCC puts it, about the impact of a transfer of a loan on the permissible interest that may be charged by the S&E. The OCC rule affects this codification by adding a paragraph to its regulations implementing Section 85 of the National Bank Act and 4G of the Homeowners Loan Act, providing that interest permissible under the statutes shall not be affected by the sale, assignment, or other transfer of the loan. The OCC rules expressly authorize regulated institutions, banks, to, in fact, sell, assign, or transfer the loans. So this was a relatively easy and straightforward extension of that authority, and one that was supported by most industry participants, and one that is necessary because in order for the safety and soundness of the originating institutions and an efficient operation of the market, we need to authorize transfer of these loans and certainty at the secondary market level. Notably, the OCC rule is styled as an interpretation of to resolve Congress's silence as to the treatment of interest to loans transferred to a non-bank assignee, and the OCC reaches its conclusion, as I said before, in part by relying on the bank's power to enter into contracts and sell, assign, or transfer those loans. The powers are clearly enumerated, and these powers, the OCC reasons, would have been understood at the enactment of the National Bank Act, and Congress's silence is permissibly resolved, according to the OCC, by the OCC under its rulemaking authority. This is actually extremely important for reasons that I'm going to talk about in a moment, but the consequence of this approach is that the OCC maintains that it was not required to follow the case-by-case preemption determination requirements imposed by the Dodd-Frank Act. The OCC takes great lengths to note that this is an interpretation of an ambiguous provision and cites the U.S. Supreme Court's decision in Chevron for the level of deference the new rule should be accorded. This is extremely important because the Chevron standard, which is the highest level of deference given to interpretations by agencies, will be upheld so long as the agency's interpretation represents a permissible construction of the statute. More on that in a moment. The OCC followed suit a few weeks later on June 25th of this summer and issued a final rule to resolve what it called two perceived statutory gaps contained in Section 27 of the FDIA. As described by the FDIC, these gaps led to uncertainty regarding at what point in time an interest rate applicable to a loan was assessed for validity under state usury laws, and the full scope of authorities granted by Section 27 to state banks as to the power to make loans. The FDIC resolved these gaps by adding a paragraph to the regulations providing that interest on a loan is permissible under Section 27 of the FDIA Act as determined on the date that the loan was made, and that permissible interest is not affected by a change in the relevant commercial paper rate after the loan was made, or the sale, assignment, or other transfer of the loan in whole or in part. Any contrary view, according to the FDIC, would present safety and soundness concerns because it increases the risk that an institution would not be able to meet liquidity events. The ability to sell loans for full value is necessary, especially during liquidity events, and ultimately taxpayers would foot the bill if banks are not able to manage liquidity and ultimately fail. Much like the OCC rule, the FDIC rule is not styled as a substantive change, but instead as an interpretation to resolve ambiguity in the statute that, as the FDIC argues, was highlighted by Madden. The OCC approaches the question, like the OC, as one of clarification based on longstanding principles, and therefore is not one of new law. The OCC notes that it does not base its determination on valid when made doctrine, only that it's a determination based on rulemaking authority for Section 27. Again, this is important from a deference perspective. The FDIC also formalized some interest-related provisions that have been longstanding interpretations related to the ability of banks to export interest from branch states and the definition of interest under the federal law. While the OCC and FDIC rules are unquestionably positive developments for those seeking regulatory certainty for the secondary market and bank-originated loans, they clearly signal the agency's willingness to come to bat to support the marketplace. They're not the end of the story. While many had hoped it would be the end, it just hasn't worked out that way, as various states have indicated their disagreement, and some, as I will discuss in a moment, have filed legal challenges to the rule. We do hope it will be the beginning of the final chapter in the Madden saga, but only time will tell if that is in fact the case. On July 29th, the California, Illinois, and New York Attorneys General filed an action in the U.S. District Court for the Northern District of California, challenging the OCC's valid when made rule and arguing that the rule impermissibly preempts state law. The arguments made by the Attorneys General are fairly straightforward. They allege that the rule is contrary to the plain language in Section 85. According to the complaint, if Congress wanted to act, it would have. The complaint also asserts that the OCC disregarded the case-by-case procedures for preemption reviews that I mentioned a few minutes ago. The Attorneys General further contend that the OCC failed to give meaningful consideration to predatory loan risk and rent-a-bank schemes. The complaint requests that the court declare that the OCC violated the Administrative Procedures Act, the APA, in issuing the rule and hold it unlawful. By saying the rule is contrary to the plain language of the statutes, the Attorneys General are setting up a disagreement related to the level of deference that should be applied to the OCC rule. What about the FDIC rule? Well, on August 20th, Attorneys General from California, Illinois, Massachusetts, Minnesota, New Jersey, New York, and North Carolina, along with the District of Columbia, filed an action again in the U.S. District Court for the Northern District of California, challenging the FDIC's rule. I won't repeat the arguments, which really mimic in many ways the arguments that are made in the OCC challenge, but also talk about the power of the banks. And like the OCC rule, they also mention that the agencies don't have the power to issue regulations that apply to non-banks, and go into greater detail in the FDIC complaint than in the OCC complaint. So that is the lay of the land. The complaint also, like the one filed against the OCC, asks the court to declare that the FDIC violated the APA in issuing the rule and hold the rule unlawful. With that, I will now turn it back over to Jeff to discuss the OCC's proposed true lender rule.
Thanks, Steve. So in July, the OCC issued a proposed rule to address when national banks and federal savings associations make a loan and are the true lender in the context of a partnership between a bank and a third party. Under the proposed rule, a bank makes a loan if, as of the origination date, it is either named as the lender in the loan agreement or it funds the loan. This is a simple and clear standard, and certainly different from the standards used by some courts to determine the true lender. As Eric noted at the outset, other standards have often focused on the totality of the circumstances or the predominant economic interest, and have presented significant concerns for secondary market purchasers and other participants when trying to determine who has in fact made a loan. Comments on the proposed rule were due last Thursday. As Steve had noted, we worked on a comment letter for the Structured Finance Association, SFA. It was a whirlwind process, and hopefully if you had comments, we were able to capture them as part of the process, and if not, I apologize. It was a short time frame we had to get it done, though. I mean, as you would imagine, there were a number of supportive comments for the OCC's proposed rule from the financial trade associations, and there were some critical comments by the state regulators. Many of the critical comments echoed some of the same points raised with respect to the valid when made rules that Steve talked about and the ensuing litigation described by Steve. While we do not know the timing or content of a final rule by the OCC at this point, we would expect a final rule before the end of the year. It's also reasonable to expect that the states will challenge this rule as they have done with the valid when made rule. We are seeing an increased interest in the true lender issue by state regulators, as evidenced by last week's public statements by the California Department of Business Oversight regarding a high-rate short-term bank partner program. And earlier this year, we saw a lawsuit by the District of Columbia in June filed against the Elevate platform, alleging that the platform and not the bank was the true lender. While the industry was generally supportive of the proposed rule, several commentators requested further clarity around the funding prong. Banks and others providing financing to lenders or loan purchasers through warehouse facilities, loan syndications, or other credit facilities could inadvertently be deemed to be the lender potentially under this current prong as written. We do not believe that the OCC intended these types of relationships to be captured within the funds the loan prong of the proposed rule, but do believe that some further clarification is required to avoid that uncertainty. While many expect that the FDIC will also come out with a similar rule, the FDIC has not publicly indicated whether it will come out with its own true lender rule, similar to the OCC's rule. that is something obviously we'll be looking for later this year and looking for some cues from the FDIC around that point. With that, I want to just kind of quickly wrap up. I know we've used a lot of time today, so I want to kind of wrap up and have a couple of quick takeaways, though, for folks. For bank partner programs, lending platforms, investors, and secondary market participants, I think a couple of things to take away from today is, one, you probably want to go back and review your new or existing bank partner programs against some of the terms set forth in the Colorado Safe Harbor. Even if you're not planning to satisfy all the requirements, it's probably a good check to see what's in your agreements and what would Colorado consider to be important. Also, I think it's important that people keep their eyes open as we expect there to be more scrutiny from the states. The Colorado settlement we expect has emboldened some of the states, as Steve has indicated, and we would expect these states to be looking into some of these other bank partner programs and looking at the true creditor issue as well. Finally, I think we're going to see continued litigation, as Steve said, between the states and the federal regulators over valid when made and then potentially against the true lender rule when it's finalized. So I think that hopefully is the beginning of the end of the Madden and the true lender litigation, but as Steve said, only time will tell. I want to thank our audience today for tuning in. A few brief reminders. You'll receive an email with a link to the recording of today's call, and the recording will also be available as a podcast on your preferred podcast platform. Lastly, as mentioned before, if you have any questions related to today's content, please email them to gfm@mayorbrown.com. Thank you again for participation. You may all disconnect now.